Please be seated. Let us resume our meeting. We haven't yet finished the first item this morning, and we will continue. And I will give the floor to the defense teams to put questions to the Office of Administration representative. However, in order to clarify the issue further, I'd like to make some remarks. Based on the existing resources, can I, as the President of the Chamber, invite national and international judges from all the chambers who have already been appointed by the magistracy, and based on Article 536 of the Code of Criminal Procedure regarding the disqualification request, it is only applicable to the sitting judges. When a judge or assistant to a party through a proceeding, or if a judge takes part in a case or participates in a decision-making in the court of the first instance or in the appealed process, or expressed his or her opinion or given legal advice, then such a judge is not allowed. So I would like to draw your attention to this particular issue regarding the existing resources that we have at the ECCC and whether they can be assigned to the second panel. I mentioned the issue this morning, and I'd like to add that to what has already been raised. In reference to the agreement between the United Nations and the Royal Government of Cambodia, in Article number 3, the compositions of the trial judges comprise 3 trial judges on the national side and 2 international judges. For the Supreme Court chamber, there are 4 national judges and 3 international judges. In paragraph number 5, the Secretary General of the United Nations will forward the list of the nominees, at least 7 nominees, and from that list, the Supreme Council of the Magistracy will appoint 5 judges in the 2 chambers. The Supreme Council of Magistracy will draw the names from the list forwarded by the Secretary General. And of course, we have 2 reserve judges at each respective chamber, 1 national and 1 international. And I'd like to get your further opinion on this issue, as we already have the regulations and the process of sending the list to the Supreme Council of Magistracy by the Secretary General. And for the first option, or if it is due to the incompatibility or the conflict of interest, then we should look at the second option. That is to select new judges to form the second panel. And for that, will there be any legal implications in relation to all the rules and regulations that I just raised? So please consider that. And I'd like now to give the floor to Nunji's defense. If you have questions to be put to the Acting Director and Deputy Director of the Office of Administration, you may take the floor.
Thank you, Mr. President. Good afternoon, Your Honours. Good afternoon, Council. Mr. President, we have two questions which we would like to pose to the Acting Director and Deputy Director. It's two questions relating to two concerns that the defense has. The first question is the following. We have had indications, or it was told to us, rather, by the Chief of the Defense Support Section, that in the event a second trial would begin after the judgment, and therefore we would be not having any trial in the first 6 or 7 months of next year, that such an event would have adverse implications or negative implications on the budget of the defense. Now, we have been told that this is just a beginning of a discussion. No decision has been made yet. Nevertheless, we would like to ask the question to both directors that in the event the trial chamber would decide a second trial would start after judgment, whether there is a substantial risk for having negative implications on the budget of our defense. That would be the first question. My second question would be related to the period in time, probably somewhere in the summer or in the fall of next year, where we are both hearing evidence in the second trial and at the same time preparing arguments for a possible appeal. As I think everybody in this courtroom will appreciate, that seems to be, at least for the defense, an almost impossible task to successfully do in the light of our present facilities. My question would be, I heard you speak earlier about a contingency plan, contingency money in respect of the international side. It is my understanding that the defense is also the national lawyer is paid from the international side. Whether it would be in theory possible, if necessary, to also apply for extra funds specifically for this period in time where two parallel things are happening at the same time, to apply for money coming from this contingency plan. So these are the two issues in question form I would like to raise.
Thank you. Since this is correctly stipulated that the whole defense portfolio is on the cost of the United Nations, I will answer both questions. So there is no distinction between national staff and international staff. It's international funding. For the first question, there has to be made a distinction between what's in the budget and what is the work plan. So there is an assumption that there will be no additional trial in parallel with the verdict writing. So then the head of DSS will have to address work plans, as is the normal standard procedure for all defense teams at all point in time. But in the budget, it's no change. The budget caters for full teams, the two teams in full, throughout the year. So on the money side, we're okay, but in practice, this has to be justified. For the second question, when we get to a double track, if the contingency is available also to defense, yes. As answer to OCP, everyone who will then have an additional cost will request so, and the request will be addressed. Thank you.
President, thank you. I would like now to give the floor to Kids and Defense to pose your questions. Counsel for Nunchi Sonaran, you may proceed. Sonaran, thank you, Mr. President, and good afternoon, Your Honors and everyone. I also have two questions to put to the Acting Director and Deputy Director. My first question is the following. I am unclear on this point, and I'd like it to be clarified by the Office of Administration so that I and other people are clear on this issue. Through the Chief of the DSS, it is understood that by 2013, some DSS staff will be reduced, including some legal staff. If that is to apply, will it take effect by the end of this year, or whether all staff will be maintained due to the proceedings in 002/02 there will be a commence soon? And that the staff will utilize all their resources to prepare for the possible appeal to the Supreme Court Chamber, as well as to prepare themselves for the proceedings in 002/02. This is my first question. And I'd like to put a second question to you. Through your responses this morning to the Chamber, both the Acting Director and the Deputy Director said the funding is flexible based on the needs of individual or respective units within the ECCC. In real situation, salaries for national staff have been delayed for 3 or 4 months. And that is part of the reason that the proceedings cannot be expeditious. And when you refer to this flexible fund, how real is it? How flexible is it? As I understood, the international side has its contingency funding, and I'd like to know more whether such a situation also applicable to the national side. Acting Director Tony Krang. Thank you, Counsel, for your question. As your first question shall be answered by my colleague Knut Rosenhog, as DSS is funded by the international side, I'd like to respond to your second question. Once again, what I stated this morning is that the proposed funding will be adopted by the principal donors soon. They are now reviewing our proposal, and we made a presentation through them last month. When I refer to the flexibility of funding, I mean that on paper, budget is based on what we foresee in the forthcoming year, that is 2014 and 2015. Flexibility also refers to the technicality of making funding a proposal, as it takes the view of all the action plans and activities. And we also have other emergency packages, for example, the fund package for the consultancy service. And that's what I refer to as the flexibility of funding. We also have a lack of cash flow. And when the funding is approved, then action plans can be put into action. But the lack of cash flow is due to the lack of funding from the principal donors, and for that there is a delay in issuing the salary, and that affects the national side since 2008. And if we think that we shall quit our work due to the delay of the salary, then we would not be here today, because that issue actually started in 2008. But overall, once the funding proposal is adopted, then of course there will be a cash flow, although there might be some delay. And that is the reality at ECCC. Thank you.
Maybe on the first question, the DSS, as said, is fully funded by the United Nations, and there has never been any delay in payment of salaries by the United Nations. So in that sense, your section is not affected by the past experience on the national side. I think there is an overlap between your question and the previous question. The assumption is the ongoing debate within DSS is work plan driven. So if there is no work, there has to be a reduction on the support staff. There is no question about the co-lawyers. But you said that the second trial will start soon. If that is the case, there will be no change. And then there is a question later on, when the appeal process starts, if there is an additional requirement. But that we will address when we get there. Thank you.
Thank you. Now, Ken upon defense, you may proceed.
Merci, Monsieur.
Thank you very much, Mr. President. Good afternoon, first and foremost, to your honors and to all parties. The crux of my comments will be based on the law. We are a tribunal here, therefore there are legal issues that must be discussed. And as my colleague has just talked about the DSS and some of our working restrictions, which, if I'm to understand correctly, there are no restrictions on our budget because it has been approved. I believe that the administration's message remains rather unclear for me. The substance has been approved, however, we are in a position to have to justify our work plan. Sir, is that indeed the case?
I assume I'm the sir. In principle, yes, but there is no change in practice. This is standard operating procedures since the outset of the court. The work plans has to be provided to the chief of DSS. So we are not changing any practice.
la pratique ne change.
Practice does not change. However, based on what we were told, we were told that there was a reduction in budget before we were even able to talk about the work that we were to carry out. Perhaps to echo the words of Judge Cartwright, our work will manifest during the evidentiary hearings, during the preparation of the appeals, and during the preparation of case 002/2. Because the work doesn't commence when the trial begins, there is an upstream process, and therefore the work has to begin now. And this must be known publicly if we are to hold future discussions and understand that the work of the defense, like that of all parties and teams and chambers, does not restrict itself to simply showing up for court hearings. And my second point, as I said that I would be speaking on the law, you stated, pursuant to your memo, and this question is for the Deputy Director, in the memo that you sent to the Supreme Court asking for clarification on the legal basis for convening a second panel of judges, that you did not receive an answer. And given the lack of a response from the Supreme Court, since this morning we've been discussing extensively about the establishment of a second panel, just based on my own interpretation of the law, I have trouble understanding how the President will actually be able to exercise the discretion to strike a second panel unless he were to call upon the reserve judges. Can it be done on an ad hoc basis, on a case-by-case basis, based on Article 3 of the agreement? It is stipulated that the alternate judges or the reserve judges may temporarily replace a judge to sit on a trial panel. But in the scenario that we do establish a second panel, which is the heart of today's discussion, we're not seeking to replace a judge, but replace, or rather call an entire new panel of judges. Therefore, my question is, legally speaking, are there clear and unequivocal legal foundations? If you asked the Supreme Court to answer the question, I suppose that you yourself were rather unsure. But from a legal standpoint, since the United Nations in New York has to take the decision, well, have they indicated whether the Supreme Court is to issue a decision, or is it the president of this trial chamber that must propose amendments to the current legal text, which, as I understand it, does not provide for the possibility to strike a new panel? Are you anticipating a response from the Supreme Court as you had originally asked? Do you expect to be receiving instructions from New York? Is this a decision to be made exclusively by the president of the trial chamber, since this is not clearly stipulated in the agreement? Therefore, those are my questions pertaining to the legal aspect of this matter.
Thank you. On the first question, when, basically summarized, when do the work commence? That's fully within the autonomy of Chief DSS. Work plans is approved by him, not me. This is traditional work in DSS. It has been like this since the outset of the court. It is up to the defense teams to stipulate when and how much resources they need and get that endorsed by the Chief DSS. What I said out about the budget is that it takes into account a full team throughout next year. Now, Is there a need for that? That is up to DSS. Second question, what the memo represents is a viewpoint from my office. In addition, I have asked at that time in the process for clarification if the Supreme Court intended to request an amendment of the agreement. If so, I needed to alert the parties to the agreement. So that's the sole intention of that first memo. The second memo emphasizes that we have looked into the administrative and logistical implications of a potential second panel. And we concluded, that the two of us, that we are ready and able to support such a decision or a continuation of the present chamber. So that's basically, the summary of the two memos. I do not have, and neither do United Nations, have a viewpoint on the way forward. That is the sole responsibility of the judicial authorities of this court. Thank you.
President Jaslavench, you may proceed.
Thank you, Mr. President. This question is addressed more to Counsel Guisset rather than the members of the administration. I understand that there are a certain number of legal issues relating to the appointment of a new panel of judges. Could we envisage the appointment of judges who would comprise a second panel, as this would have an impact on the commencement of the hearings? As there could be requests for the review of whether or not the judges have been legally appointed, could have an impact on the unfolding of the proceedings. Counsel Guisset, since this morning,
que tout le monde a envie de montrer.
everybody understands that we have to move forward. The co-prosecutor is suggesting that we can start in February, and the defense is ready, and the trial chamber has given all parties a chance to speak, and there's general consensus to move expeditiously. And during a previous TMM, there is agreement that we must move swiftly, but we cannot make any mistakes. Yes, we must move quickly, but we must know what direction we're heading in. And as I want to know where I'm going, when a question is being put on the possible establishment of a second panel, I am not the one responsible for the possible appointment of the judges, but I am a lawyer and I have to rely on the law. And before I can even contest or object to what it says, I have to understand what the state of affairs is. If I am to take for granted the explanations that we are being given, then I cannot make any objections. But I am seeking to delve further into these legal aspects. If we are to be found before a new panel, you've talked about appointing reserve judges, you've talked about appointing judges who may have served within the OCIG, or even members of the OCP. You are fully aware that I am a defense lawyer and I'm here to defend my client's rights. And if there's even a possibility for someone from the OCIJ or from the OCP to sit on the bench of judges to try my client, well, I cannot be worthy of the name of a defense lawyer. I'm looking to understand what the possibilities are for appointing a second panel. But firstly, I wish to determine exactly what the legal foundations are. You've understood that throughout the proceedings we have launched objections and grievances, and we have challenged decisions with which we did not agree. But we are here to make law, and we have to look at the Constitution. We have to understand what the agreements are and what laws apply if a second panel were to be convened. And if I look at other international criminal tribunals, well, I think it's entirely consistent with what is foreseen in Article 3, where there is a possibility to strike a new chamber and designation. However, I've been given no legal guarantees or guarantees that my client's rights will be protected. Now, I understand that on the co-prosecutor side, they want to have all of the evidence from Case 1 admitted. But does that also mean that all of the decisions from the first trial will also stand and be considered facts, or will they still be subject to appeal before the Supreme Court? If the new judges are to count on the principle that all evidence is admitted, well, when you will have issued your judgment, will you continue with the second trial, and the newly appointed judges and the new support staff will have their duties terminated? As a defense lawyer, I am perfectly entitled to ask such questions. What is going to happen if there is no definitive decision? This new chamber comprised of new judges, we're talking about a second panel, but really it is a second trial chamber. Let's call a spade a spade. If it's new, it's an entirely new entity. It is a new chamber, and if there are to be new judges who will adjudicate, obviously, we will undertake the necessary. And this is not a matter of wasting time. We are just simply making sure that my client is given a completely fair trial. What are the legal basis for the establishment of a second panel? I think this has been discussed extensively, but there's been no reference to the law. We understand the position of the administration. But is it indeed the body that may issue a legal stance, or is there a higher authority? And perhaps the other parties could ask the same question. And again, I just want to understand the crux, the essence of the matter. Just on what basis, on what legal basis, in text, in law, can such a panel be established? And if it is created, what are its powers, what are its restrictions? And what is the status of the decisions that will have been or have been issued by your Honourable Chamber? What about the severance of several smaller trials, the types of witnesses we can call, the types of questions we can ask them? Those are matters that have to be resolved before we can start a second trial. It makes up the legal basis. And thirdly, from the point we start, because the co-prosecutors seem to want to convince us that we can start in February, they are quite eager about this. Well, on what basis can we start 02/2? Well, according to the co-prosecutors, or rather, who is going to decide on this matter? Is it you, or is it going to be a new panel? That this is unclear. And we want to make sure that it is crystal clear. We're not seeking to cause any delays, and this has to be decided upon before a second panel is convened and before a second trial begins. If this is just for cosmetics and to please the donors and show the public that we are moving swiftly, well, if there's no substance behind that, then the exercise is completely futile. I am a defense lawyer. I know that I may not be everyone's best friend, but I'm here to practice law. That is my job. what are points of reference? Our client is the person who's going to be judged. I know that there are some administrative contingencies, but
Third point, I'm very happy to hear that it's DSS that's going to be taking the decisions, because our debates and discussions will be facilitated in the coming days. But I nevertheless need to remind you that even to prepare preliminary hearings and to decide upon the scope, that's the work of everybody, all the parties. Now, I cannot speak on everybody's behalf, on behalf of the civil parties or the co-prosecutors. But when we are told that we're going to cut down, and we have been told that there are going to be cuts, and people who have to organise their daily lives are wondering how they're going to be employed in the future, because if you're not sure that you've got a job, then obviously you seek one elsewhere, and that has an effect on the way that we are able to prepare our positions. If you have people who are impregnated with the case and who then go elsewhere because they have heard that the teams are going to be cut down over a few months or during a few months, then I rather sympathise with them. If the most ambitious statements of the co-prosecutors are that we ought to be ready by the end of February, well, I can tell you quite simply that no, I won't be ready. And this is in no way any kind of delaying tactic, whether this is at the national, international level on the defence side. We started these files at the end of 2011. We never asked for any delays. We did absolutely everything we could with the resources we had available to us. And now, if we have a chance of just working in a normal kind of way, fine. The National Co-Prosecutor talked about public holidays. Goodness me, how many weekends have gone by without my team having had any holidays whatsoever? Preparation of a trial doesn't start 1 month before the trial starts. It starts right now. And it's the same thing with the appeal. You can't launch an appeal while you are also carrying out hearings. And this is just the tip of the iceberg. And it's very important that we talk about this publicly, because it might acquaint the public and the donors that it's not just a matter of turning up to hearings from 9 to 4 in the afternoon, but that there's an enormous amount of background work that goes with it and which never really ceases. Thank you.
The President, Judge Cartwright, you may proceed.
Yes, thank you very much, President. I just wish to explore further with Ms. Gisay some of the comments that she's made. In summary, I think everybody in this courtroom understands that the work related to a trial is ongoing even when the court is not sitting. That is true for the defence. It's true for the prosecutors and the lead co-lawyers, and of course it's true also for the judges. So I don't think there's any divergence of opinion there. Perhaps the public and some commentators don't understand that, but as I said earlier, sitting in court is the least of our work in the sense of the time invested in it. However, I have not been very clear about the defence team for Kyo Sampan's views on the legal issues surrounding the appointment or otherwise of a second panel. You have raised a lot of questions, but one of the reasons that we are holding this meeting, which in a sense is moving us all off onto a second path other than completing the verdict in the case of the trial chamber and preparing for the second trial in the case of all of us, we've had to move off onto a second path, but we have to do this. The Supreme Court has made this clear to us, and we want to make sure we get all the information so that we can make, or particularly in the case of a second panel, the President can make an informed, legally based decision. So it would be very helpful if you could give us your legal views, submissions, on what is open legally to the President in this issue of the appointment of a second panel, and the Nguyen Chia team can also do the same. It would really help us to speed the process and assist the President in making a decision. Thank you.
Madame le juge Cartwright.
Your Honour, Judge Cartwright, I think you're being very hard with me because you're asking me to answer a question which I thought the Supreme Court, in its decision that it handed down about 6 months after the appeals made by the parties, which had been announced earlier, I thought that we would have the answer to that question from the Supreme Court. Unfortunately, all I have are questions to ask. I can say that if the foundations behind this second panel, well, for me, Article 3 of the agreement, only provides for the possibility of appointing reserve judges in addition to those that sit normally. For me, this only refers to exceptional circumstances, and it cannot be the basis for the establishment of a second panel. Now, if in the Supreme Court and if in New York that's the position taken, I will look at the other texts, but on my initial reading, that's my interpretation. If that's the textual basis we are working on, then I'm afraid I'm not moving along the same road as the administration. I see limits in that. Now, going to extremes, rather beyond the letter of the text, one might say that the implications of the second panel on the guarantees of the defence rights regarding the basis for the second panel and how it will be defined. Can it be said that it's a second chamber? Well, I think that all of these legal points are things that we must all make submissions on, because as far as international jurisprudence goes, I haven't seen this anywhere else, or national for that matter. And since the Supreme Court has not given us any further guidance and not been very precise, then obviously we will have to submit our views to you in writing. And right now, as I stand, I have no immediate solution to offer you.
The President, thank you, Judge Cartwright.
Yes, Ms. Gise, I think I certainly speak for myself and probably for the entire trial chamber. We do not want to spend any more time on the legal and other issues surrounding the appointment of a second panel. We do not want to ask for written submissions. We do not want to have another trial management meeting. This is, as I have said, a diversion from the work of everyone in this courtroom. You have indicated your legal views on Article 3.8. Is there any other matter you would wish to raise? And also, can I just summarise what you said earlier? The Chamber is certainly not asking you to promise that you won't appeal or seek the disqualification of any judge, not asking that. But the indication at the moment from you is you don't know yet what course of action you will take. And of course, if it's in the interests of your client to seek the disqualification of any or all the judges, then that will inevitably mean a delay, which is not your responsibility. That's just the way it is. But have I summarised that part correctly? And is there any other legal issues surrounding the appointment of a second panel that you would wish to raise now, because this is your best and possibly only chance?
Sous réserve des observations.
With the reservations of other observations that may be submitted by other parties, Judge Cartwright, for the moment, the only legal issue that I wish to bring forth here on the question of the second panel is this Article 3, and so that is what I'm making observations on. If other elements come up in the course of our discussion, I may wish to respond to those, but that is all for the moment. Thank you, Madam.
The Nuon-Chea team, do you have any legal issues you wish to raise in relation to the appointment of a second panel?
Thank you, Judge Cartwright. We can be very short on this. Our view is that our preliminary view is that there are no legal obstacles against the establishment of a second panel. Our only avenue in approaching this matter is once new judges are appointed, whether there are issues of appearance of bias, but that's an issue within, I would say, the trial itself. But going back to the very beginning, we don't see any objections, any legal objections to the appointment of a second panel.
A follow-up, I think Judge Levagne may also have some questions. You've raised the issue of the appearance of bias. Of course, this is a matter that was initially raised, I think, without any party raising it. It was initially raised by the Supreme Court, but has not been raised again in its second decision. Do you see that there is any significance in that omission in the second Supreme Court decision?
Not necessarily. To us, it depends on who ultimately are going to be the 5 possible new judges. If we feel that with one or more judges there might be issues in respect of appearance of bias, then we will raise it. If right now, if we don't know the names of the potentially new judges, then we have no problems to raise. And the fact that the Supreme Court chamber didn't address it anymore is, for us, not an issue.
The President, Judge Levagne, you may proceed.
Thank you, Mr. President. From what I understood from the explanations given by Counsel Guisset, I would have to express a certain number of has a certain number of reservations about the legal framework surrounding the appointment of a second panel of judges, and I understand that such reservations come from the fact that one may well wonder if the President will be appointing reserve judges or titular judges. It is quite true that 3.8 only refers to reserve judges. It is also true that in the legal agreement there is only one single trial chamber provided for, and that is composed of 5 titular judges and not 10. Am I more or less in step with your comments there, Counsel? And another question to the Nuon-Chea team, please. Do you believe that the President should be appointing reserve judges, or should he be appointing titular judges and setting up a second chamber? You say that there's no problem for you, but is this a second chamber of titular judges or of reserve judges, please? And then perhaps subsequently we can hear the views of other parties on this point as well. Thank you.
Judge Levagne, to us it's completely equal. I can understand there's much to be said to the appointment of Judge Fence into a new trial chamber because he has extensive knowledge as to the case file. We even could contemplate the possibility of not appointing reserve judges, but judges from other chambers who are in fact now active. At the end of the day, for us it's only important who are the judges sitting and dealing with the matters of importance to our client. How the avenue is, that is of less concern to the Nunchia defense team. We don't see any legal obstacles to the appointment of reserve judges, titular judges, or even judges from other chambers who are presently active. Our only framework of reference is the appearance of possible bias once appointed. That is, I think, how we should see it.
Et donc tout ceci.
So, all of this is on the basis of discussion within the framework of Article 3. For your reading of Article 3, this is how it would go.
To be honest, to be part of a discussion of which judges will deal with the case of my client, it's very unusual for me. Normally, I end up at the beginning of a trial and I see who the judges are. And if I, for some reason, think that one of these 5 judges or more could be potentially biased because of earlier decisions, then I will raise the issue. Before that, to be honest, I don't really have that much to say as to the avenue that the that the President of the Trial Chamber is taking. I would not go so far as it is of no concern to us, but basically that is what it boils down to. We'll see, we'll cross the bridge when we get there. How you get there, that is up to you. If there is an appearance of bias once appointed, then we will raise the issue. But of course, we can say up front if it's going to be judges who have had no interference whatsoever with any previous decisions, that the chances of us raising the issue of bias are going to be smaller and maybe even non-existent.
Oui, Monsieur.
Mr. President, with your permission, sir, there is a point I perhaps omitted just now. The question of whether or not there is a second panel also reflects our position, which is that I don't think that there can be a second trial without there being a final verdict. And I have to recall, well, I do think that we do have legal interpretations of a certain kind of variable geometry, but at one point in time the prosecution had the same position, that before starting the 002/2 there was no question at all of a second panel of judges because we needed a final verdict. Why? Because things will go faster. Because there are a certain number of central elements concerning modes of responsibility that have to be resolved and which will have an impact on the way the second trial will unfold, the questions that will be put and the final scope of it. These are highly legal issues, and I do not know if we should continue on this legal path or if we are ceding to certain political contingencies in this general discussion. Thank you.
The President, Counsel, you may proceed.
Thank you, Mr. President. Good afternoon. My name is Beni Ye. I speak today on behalf of international lead co-lawyer Elizabeth Simonefort, who is not here today. I would like to briefly convey the position of the civil parties on the question whether establishment of a second panel is necessary or not. In our view, a second panel is not necessary, and we do not support the establishment of a second panel. First of all, on the authority of the President to appoint judges, be it from reserve judges or be it new judges, for such a second panel, in our view, the interpretation that the Supreme Court is taking on Article 3 of the ECCC agreement is highly doubtful. But even if we follow this interpretation of a wording which is very clearly only speaking about a chamber of 5 judges, as has been raised before by Judge Laverne and the President, even if we follow this reading and assume that the President has the authority to appoint a second panel, the Supreme Court still grants the President a discretion to do so where it is necessitated by the interest of justice. And in our view, the interest of justice does not call for the creation of a second panel because it would not allow the second trial to proceed in a more expeditious or a more efficient way. First, according to what we heard this morning, the recruitment of judges and support staff for such a second panel would need a considerable amount of time. For the national judges, we heard that even if they were to be recruited from a pool of reserve judges, a royal decree would be necessary. For the international judges, it would have to be ensured that the candidates on the list of nominees that is currently in the hands of the Secretary General are available, and again, a royal decree would be necessary. For the support staff, the full recruitment process would be required, from announcement over the interviews to the positioning. And on this point, we do not believe that hiring interim support staff, as suggested by the Office of Administration, that can allow for a shorter recruitment process is a not valid option. Because if you do so, the old staff that will come back in after this interim support staff will leave would have to process what had been happening in the meantime, which also can cause delay and interruption. So in all, it would not be any more expeditious to try to establish a second panel. Secondly, it would also not be more efficient because the second panel would need to familiarize itself with the extensive material that has been presented in case 002/01, as has been pointed out by the international co-prosecutors. This would slow down the process considerably. Even if such a second panel could be established, maybe just a short time before the verdict is finished and the current trial chamber can already continue to work on the case 00/02. So in summary, the position of the civil parties is that we do not need a second panel. We rather prefer the continuation of case 002/02 by the current trial chamber as soon as possible. In our view, as soon as possible would mean to start the preparations of the trial, including defining the scope, defining the lists of civil parties, witnesses, and experts, etc., before the issues of the judgment, and start with the hearings themselves following the issues of the judgment. I hope this position is clear. Thank you.
Thank you, Counsel. And Counsel Kong Som-on, you may proceed. Kong Som-on, thank you, Mr. President, and good afternoon, Your Honors and everyone. I will be brief. Regarding our position on the establishment of the second panel, and based on your request for us to look at the existing and current resources, I believe it is not possible for the creation of such a panel. There is no law that gives the legal authority to Your Honor the President to appoint the existing judges from other chambers, for instance from the Supreme Court chamber or the pretrial chamber, to form part of the second panel. it is likely that the President can do so without looking at the current or existing rules, laws and regulations. Only after the amendment to such rules or regulations, it could be the President of the Supreme Court chamber, or with the political will, such appointment can be made. If the right of my client is affected, then of course we would object to such an establishment. If amendment to the current laws and regulations is needed, then there would be a proper procedure put in request to the stakeholders or to the National Assembly to amend such law. Our position is that that is beyond the responsibility of my defense team. I also heard the clarification by the Office of Administration that there is no financial or administrative impediment for such establishment. I still have doubt on that. And when it comes to the ability to amend the agreement or the existing ECCC law, it is not that easy to proceed. All major stakeholders, including the United Nations, the Royal Government of Cambodia, and the Assembly, needs to participate fully. And if a request is made through the Assembly for amendment, it will take some time. And if we think of the time that the current trial chamber can proceed in 02 or 02, which is likely to take place in June next year, then what is the point of the establishment of the second panel? And can the second panel be established in May 2014 or as early as January 2014? So you have to weigh this kind of advantage of establishing the second panel. And it is my opinion, it's not that beneficial to us. President, thank you, Council, for your comment and opinion. The time is now appropriate for a short break. The prosecutor, you might make a brief remark.
I would ask, Your Honors, to seek a clarification from my colleagues as to their position. Perhaps you can do it after the break, but I can briefly state the questions I have. For the Q Sampan defense, they've indicated that they don't believe the trial should continue, case 0202, until a final judgment. In their view, is a final judgment a trial verdict or an appeal judgment? And secondly, I believe they've discussed the issue of judges who took part in prior decisions. Can they indicate that if the trial judgment goes against their client, for example, finds that Q Sampan was part of a joint criminal enterprise to commit these crimes, that they will not then seek the disqualification of Your Honors, and then seek to have a whole new trial panel 8 months from now? So what is their position on those 2 points? And as to the civil parties, when they indicated that the trial, in their view, should start after the judgment, how do they reconcile that with the Supreme Court decision saying that 8 months, we cannot wait 8 months for a trial judgment before beginning, and that to do so would call into question the continued detention of the accused? What is their position on that? So I would ask the parties, my colleagues, if they could, to clarify that.
President, Councillor Gongsom-On, can you respond to that question? Gongsom-On, thank you, President. It is our position to have a final judgment before we continue in case 002. And that is the point that we have raised earlier. And my previous response is to focus on the establishment or the possibility of establishment for the second panel. Our Kyiu Sampon's defense team that is, our position in 002/02 remains unchanged. But we also look at the interest of justice and to see whether 02/02 carry more weight and offer better benefit when a new panel of judges is established. We also look at the time frame for the establishment of the second panel, and to us, it seems that it will take quite some time to make it happen. It doesn't happen quickly, and even if it can be established, our request to guarantee the right of our client, Kyiu Sampon, remains unchanged. President, Counsel, and the representative of the lead co-lawyer, would you respond to the question?
Thank you, Mr. President. Just to clarify what I just said, in the position of the civil parties, we favor the start of the preparation for the trial as soon as possible, which means during the writing of the judgment, and then to continue with the hearings after the judgment is finished writing. Because during the preparation phase, there will be also considerable time allotted to the parties to prepare their lists of documents, to prepare their lists of witnesses and civil parties and experts, which would allow us to start working on the second case already. So if I understand it correctly, this would be within the 8 months that is requested by the Supreme Court.
But, good afternoon, Mr. President, Jonas, and everyone. And I'd like to add what has been said by my colleague regarding our position for the commencement of the trial in case 002/02, that is the substantive proceeding. Benny Ye has already raised our position that the substantive hearing can be started after the issuance of the judgment. There is also another possibility through our extensive discussions with other civil party lawyers, is that if it is possible, the substantive hearing can also commence before the issuance of the judgment. For instance, if a judgment is issued in June, then the substantive hearing can start earlier than June if it's possible. President, thank you all for your comments and opinions. We will take a break now and resume at 3 p.m. to continue our meeting.